Good morning, everyone. Myself, I am Dr. S. Gopinath, Professor and Head of Electronics and Communication Engineering Department, Karpagam Institute of Technology, Coimbatore. Today, I am going to just give the overview of an insight to intellectual property rights and patent filing. Intellectual property rights. It is the rights given to the person over the creation of mind. It may be your creativity, your applying thoughts, your idea, in which we are going to apply for the implementation. It will be turned into a product or project, or it may be any kind of methodology. So over your creativity, how you are going to develop a product. So this is the rights given to you. IP is an intangible property. So generally the property can be divided into two categories. One is tangible property and another one is intangible property. So tangible properties are the permanent one, that may be a land, houses, estate, car. But intangible property is an intellectual property. IP is coming under the intangible property. It may be your wealth, or it can be easily appropriated, reproduced. Based on the marginal cost of reproduction, it may be negligible. Why we need to protect the IP? Suppose if you are not protecting your IP, what will happen? Someone can use your own idea and convert into a product and sell it in the market. They can gain profit from that. Okay. So in order to protect IP, what are the advantages we can have? Capital expenditure for new product we can attain. We can apply it for research and development. We can do in both marketing and advertisement of our product. There will be no freeloaders. We can also maintain the loyal followers to our product. Based on that, we can attain more profit from them. That is why we need to protect our IP. So, IP as a property, it can be sold to someone. It can be bought from anyone. It can be leased or rent to given anyone. It can be passed under a will. It can be assigned to someone. So there are so many advantages of IP. If you have your investment, you can, through your IP, you can start your own business, or someone have a IP, you can buy it from them. You can start your own enterprises or startup or any initiatives you can do based on the intellectual property. So these are the different categories of intellectual property rights. So first one is patent. So patent is a kind of IP where it applies to based on the methodology, based on the tools, based on the availability of the component, we can convert it as a patent. And second one is design. Design may be anything. It will be appearance of the product or appearance of the thing what we have, which will differentiate from other organization. Trademark. It may be a logo with slogan, or any symbol which indicate the particular unique quality of the company. That is trademark. And next one is trade secret. So the secret, all of you know that if some company is organizing, is having a lot of employee, they are protecting their employee details through their passport. It is a secret. So these secrets should not be revealed to the any other third party or any other third organization. It should be well protected. It should not be open to anybody. So, for an example, all of you know that Coca-Cola was invented in 1886. The taste of Coca-Cola is very unique while comparing to Pepsi or other drinks. Only in the Coca-Cola organization, only two people know the formula of the Coca-Cola drinks. None of them know about the formula of Coca-Cola. So that is the trade secret. And geographical indicator. So geographical indication is given to a particular product based on the climatic and unique characteristics of the product. So in India, Tamil Nadu has more than 30 GI tag owned and copyright. So copyrights means it may be a poem or article or a book or chapter or a song or a drawing or a painting or sketching. Everything can be protected with the copyright. And last one is semiconductor design. This is the newly invented intellectual property rights. It was invented in 2000. So very familiar. So based on the semiconductor based product. Suppose if you have invented a product, it may be any PCB layout or any automation kit based on the semiconductor. Suppose if you have developed, that can be coming under the intellectual property rights under Semiconductor Act. So these are all the intellectual property. What are the laws and when it was invented for protection of the intellectual property? Copyright Act. It was invented in 1987. Trademark Act. It was invented in 1976. Patent Act. It was invented in 1970. Industrial Design Act. It was invented in 1996. And last one, Geographical Indication Act. It was invented in 2000 in India. First, we are going to discuss about patent. It is an exclusive right for bearing the true and first inventor of a product or process granted by the government for a limited period to exclude others from making, using, selling, or importing the patented product or process without his or her consent in exchange of full disclosure of his invention. It means that patents should be on your own. What you have developed, it may be your methodology, it may be a tool, it may be a product, it may be a project, or whatever the component or mixing of component it may be. You are the sole author of this product. So it can be protected using this intellectual property right, that is patent. So in India, patent filing is valid up to 20 years. Suppose if you are going to file a patent this year, 2024, it will be valid for your own. It will be owned to you for another 20 years in your credit up to 2044. In India, how many patents filed still now? So according to the WIPO report, we have heard 66,440 patents filed in India. So compared to China, China have more patent filing and patent grants, more than 6 lakh patent to their credit. In India, Gurjit Singh Sandhu has filed more than 1,300 patent to his credit. He is an engineer from the field of electrical engineering department. So these are the patent jurisdictions available in India for granting our patent. There are 4 locations. One is Mumbai, second one is Chennai, third one is New Delhi, and fourth one is Calcutta. So this is for our Indian patent filing jurisdiction, patent office branches located in India. If you want to file your patent in international level, you can approach this organization, that is WIPO, World Intellectual Property Organization, 1967, established in the year of 1967, located in Geneva. Patent Cooperation Treaty, 1970, US. World Trade Organization, again Geneva, established in the year of 1995. So what are the things can be patentable? in India. Product can be patentable. Tools or apparatus for producing the product can be patentable. The process can be patentable. The composition of matter can be patentable, and methodology can be patentable. These are the 5 things can be patentable in India. Okay. What are the documents required for patent filing? See, there are two types of patent. One is a utility patent and another one is a design patent. Suppose if you want to file your utility patent, so you have to first take these forms. Form number 1, form number 2, form number 3, that is application, specification of your product or methodology or tool, whatever it may be. Undertaking section, that is form number 3, and drawings, including that you have to file your description of the product. What are the things you are going to claim in your product? And last one is power of authority. These are all the necessary documents which is required for filing the patent in India. How you are going to draft patent application? First one, you have to enter your title of your innovation or invention, background and summary of the invention. When it was, whether first before you are going to file your patent, first you have to do the patent searching, whether it is already existed or not, or if it is exist means how we are going to modify, how we are going to enhance the product with your own idea and knowledge, and abstract and drawings of your product or invention, and you have to give the elaborate description of the design and drawings and patent claims, and including that cross reference related to your application. So this is the patent law procedure, okay, under the Act 1970. Suppose if we are an inventor, there are two categories in patent application. First one is inventor and another one is applicant. So applicant is the main and sole responsibility of the product. He is the full ownership of the patent. Suppose if you have an idea or methodology, have a documents, you can directly submit in offline mode in the patent office. In Tamil Nadu, it is located in Chennai. You can directly go to the office and submit all the necessary documents to the patent officer. He will give the acknowledgement. Within 15 days, your patent will be published in online mode. So these are all the patent searching options available before if you are going to file your patent. Text search, simple search, advanced search, syntax or command based search, number search, structure search. So these search options are available for finding whether existed inventions available in the website. Okay, through that you can find. What are the patent search tools available in the market? There are two modes available. One is paid mode and another one is free mode. I can suggest you to refer the ipindiaservices.gov.in public search. It is a free searching tool available in Google. You can directly search it through the different various searching options: patent scope, JPO, IPDL, USPTO. These are all for the finding the international patent. And this one is the paid mode, that is worldwide address. Micropatent, surf, ip.com, caseway. So these are all the paid searching tools. Better you can choose the ipindiaservices.gov.in for finding your patent search. So this is a snapshot of the IP India Services patent search page. Here I have given the patent searching option in the left column. You can find different searching option based on the abstract, title, description, application date, patent title. So many searching options available in left side. Through that you can find your existing patent which is similar to your methodology or tool, or what you are going to file. Okay, so through that If it is already existed, you can just modify or enhance through the parameters or through the tools, or if it is not present, you can directly patent. There are two modes for patent filing. One is online mode and another one is offline mode. For filing a patent in online mode, first you should get a e-signature. After that only you will be able to file it. So what will happen if someone used our idea or tools and sell it into the market and gained from that? The better option is you can file a complaint, that is infringement of a patent. If a competitor makes use, sells, offers to sell or import an embodiment of the invention without the permission of patent owner, there are two types of infringement. One is direct infringement and another one is indirect infringement. So what are the consequences they will face? Injunction. It means that all the product may be removed from the market, destruction of your product, paying damages to the patent owner, that is the applicant or inventor, and finally the competitor without the permission of patent owner, if they gained a lot of money or profit, they can be directly sent into the imprisonment. So this is the infringement of patent filing. And next one is registration fees. What is the registration fees required for patent filing? See, there are two modes. Suppose if you are availing for examination for patent grant, you have to pay 8,500 rupees for patent filing as well as granting and request for examination. Or if you are not willing for examination, you just file your patent. Okay, means you have to pay 4,500. So this is the final conclusion what we have seen right now. So IP is a category of intangible property which ensures the creation of human intellect, encompasses copyrights, patent, trademark, trade secret, and so many IP rights. What is the main purpose? Encourage the creation of large variety of intellectual goods and economic incentive it can give, and allow the people to profit from the information and intellectual goods that they can create. So IP is a very good thing because it is your own idea, it's your creativity, your knowledge. We can initiate your own startup company through that, through the IP, you can get lot of benefit from that. So thanks for the opportunity given to me. Thanks a lot. Goodbye.